Question is that parts 1 and 2 and clauses 1 to 3 stand apart. The Honourable Phil Goff.
Mr Chairman, this bill is what is described as a cognate bill with the bill that we have just discussed, and they have a lot in common in the sense that both are designed to provide for extraordinary detention or supervision of people who have completed their term, their finite term in prison, but are deemed to be at very high risk of offending if they are returned to the community. The difference with the Parole Extended Supervision Orders bill is this. It doesn't actually detain people in prison conditions. It allows people to live out in the community, but under close supervision. And for the first year of the extended supervision order, they may be under very, very close supervision. And this is a bill that in fact has its origins back in 2004 actually, when that's when it went through, when I was Minister of Justice. And I introduced the bill, because a group of offenders had been released from care in the community under the old legislation dealing with mentally ill patients. They were found not to be mentally ill, they were found to be personality disordered, and because personality disordered did not meet the requirements for detention under the Mental Health Act, they were released. And it came to my attention through a psychiatric nurse called Neil Pugmire that worked up in the Manawatu at Lake Alice. And he said, I've drawn this to the attention of the Minister, I've drawn this to the attention of everybody I possibly can. I have worked with these people, I know these people, they are not capable of controlling or exercising control over their own actions, and they will almost certainly reoffend, I should say, if not returned to custody. And he was actually sacked from his job for doing that, which I thought was grossly unjust. He was issuing a public warning designed to enhance the safety of the community. And the thing was that Neil Pugmire was absolutely right. These offenders went on to offend, and to offend seriously. The offender that came to my attention was an offender who had a very low IQ. It was about 90. And he was actually imprisoned again because he raped a child under the age of 2 that nearly resulted in the death of that child. I say that not for the value of shocking the House, but to say this was the consequence of a person like Lloyd McIntosh, who was totally incapable of controlling his urges, had no empathy or understanding of the impact of his actions on his victims, and who his mother warned us would keep on reoffending if he was not under some form of supervision, and indeed so did he. He was one of the group of people under extended supervision orders that said that they welcomed that because it kept others safe from them and them safe from the actions that they would otherwise take. Now, I'm not pretending that everybody welcomes the fact that they are subject to supervision, but I am saying there is this category of people, just as there were for the public protection orders, where the balance changes from the right of a person having completed their sentence to be released into the community as against the right of vulnerable people like children in the community to be protected against people who almost certainly will reoffend as soon as the opportunity arises. And every time, sir, I come down on the side of the rights of the vulnerable, particularly children, and there are 335 people who have been restrained under extended supervision orders because they have offended sexually against children. What does this bill do, and why is it necessary? Well, the 10-year period under which a person can be confined under an extended supervision order comes to an end early next year. And the first of those those prisoners, Lloyd McIntosh, will be released at that stage. And I know the Minister for Corrections and the Minister of Justice will have the same nightmares about that as I had at the time when he was, Mr Chairman,
The Honourable Phil Goff.
I had at the time when he was due for release. So what this bill does, allows the indefinite extension of an extended supervision order beyond the 10 years. And I understand that about a third, about 70 of the 225 currently under extended supervision orders will probably have their extended supervision extended beyond a 10-year period. Now, this is different from public protection orders because they are not detained in prison-like facilities. They are in the community but under intensive supervision. But ironically, public protection orders are deemed to be consistent with the Bill of Rights because it's a civil order, and what we are doing here is deemed by the Attorney-General to be inconsistent with the Bill of Rights because it is under a criminal regime. So they have far more rights, but this bill is seen as breaching the Bill of Rights. And I never breached the New Zealand Bill of Rights or support the breaching of the Bill of Rights lightly. I take the rights set out in that Act incredibly seriously. But as I said before, in the instance of these individuals, I believe that you have to consider the rights of those that they will almost certainly offend against to be protected from them. This bill not only extends the period beyond 10 years, but it also is extended to cover some adult sex offenders against adults, I should say, and against some very serious violent offenders. The numbers are much smaller, but they are equally categorised as being highly likely to reoffend. My wish is that actually the judge in the first instance had have simply sentenced them to preventive detention. That would have been a solution totally within the Bill of Rights, and they could have been kept indefinitely in prison, and when released they could have been re-imprisoned at any time that they breached the conditions of their release. But a judge at the time of sentencing does not have perfect information. And often after a person has been in prison for a long period of time, those that have worked every day with that person, often as health professionals and psychologists, have a better understanding of the risks posed. And these extended supervision orders will not be imposed on people other than those that health professionals believe it is vital to have this form of supervision over them to prevent them reoffending again. I do need to read to the House what the Attorney-General has said. He said in his Bill of Rights vet here, he says, "I conclude that it appears to be inconsistent with the rights against the imposition of retroactive penalties and double jeopardy, which are affirmed by Section 26 of the Bill of Rights Act." He acknowledges that the extended supervision order will only be imposed on offenders who have committed serious sexual offences and where the court that sentenced that offender is satisfied that they pose a high risk of committing further such offences. He acknowledges also that there are new safeguards against the extended supervision orders being imposed unnecessarily in two ways, extending the matters that must be addressed by the health assessor's report, and the court has to be satisfied that there is a pervasive pattern of serious sexual or violent offending before making an order. Any risk of sexual reoffending must be high. The risk of reoffending, violent reoffending, must be very high, and these orders are reviewed by the Parole Board every 2 years. At the Select Committee, I explored with officials whether it was possible to make this a civil rather than a criminal regime, which would not in any material sense affect the way in which the offenders were being treated, but would bring us technically within the Bill of Rights and outside. Now, I think in large part because it would have created a lot of work and there was a limited period of time before these orders had to be in place, officials said, no, it's not really worth the candle. I would have liked a longer period of time so that we could have explored that more thoroughly. If we could have avoided breaching the Bill of Rights, that would have been far the better alternative. But in the end, Mr. Chairman, I was persuaded that even if we'd been able to get this new civil regime, as we have with public protection orders, actually it wouldn't have protected in any material way the way in which these people who have been convicted of very serious offences would be treated, and it wouldn't in practice affect the rights that they exercised. Mr Speaker, while I express reluctance about the breach of the Bill of Rights, I nevertheless support this bill.